subject in particular is going to be civil litigation and class actions. So let's go ahead and get started. So part one, what we're going to cover are the basics of a civil lawsuit first before delving into what a class action entails. First off, you have what you call the initiation of the lawsuit. You have discovery, you have mediation and settlement efforts, and then you go to trial. So next slide, please. A little bit about the initiation of the lawsuit. For example, you have breach of contract lawsuits, but you have all other sorts of lawsuits: employment discrimination, personal injury, slip and fall, intellectual property. So you draft it up and then you have it served. And that's what we have here in the second picture. Is if you're suing an individual, you just have to serve that person or serve someone at the place where the person resides who's of suitable age and discretion. Thereafter, the defendant, who once they're served, they do have to file a responsive pleading to the complaint, generally within 30 days. Typically it's an answer, but sometimes it can be a motion to dismiss, or as they call it here in California, a demur. Once those issues are once we move past that, the parties delve into discovery, and discovery is the process wherein the parties get information from each other, more details about the claims and the defenses, if you will. So discovery can entail depositions, which is an actual in-person interrogation, if you will, of the other party. It can also entail written discovery, which can be requests for information, or as we call it, special interrogatories, or requests for production of documents and things. And it can also be requests for admissions, where we ask for a party to admit and deny certain facts and information in a case. And all of this will just help the parties gain a better understanding of the strengths and weaknesses of a case, and perhaps where the merits are, and maybe even what a case is worth as far as settlement is concerned. All right, so speaking of which, once the parties complete discovery, then they can try to enter into mediation and settlement. Now, I just want to clarify that you can also definitely do mediation and settlement, pursue that even before discovery. You could even do that before you file an answer to a lawsuit. You could even do that before you file a complaint. But I guess the point being is that there are a lot of parties, they want to complete all the discovery before they talk settlement, because they need to get all the facts. They need to know whether the defenses are legitimate. They need to know whether the claims are legitimate. But it can also be discovery is also a very expensive process. So sometimes parties, based on the information they already have, they may just forego doing any extensive discovery, just trying to go to a mediation and a settlement conference and getting it resolved. Because see, the problem is, once you try to pursue settlement after discovery, maybe the parties have already spent so much on attorney's fees that they may not want to be interested in settlement anymore, and they may just want to go all the way because they've reached a point of no return. But in any event, this is oftentimes the next step. And a mediation is exactly like what it sounds. You retain someone on an hourly basis, a neutral party who has experience functioning as a neutral and doing mediations. All right. And lastly, if the parties don't settle, you have a trial. And there's two types of trials. You generally have, one is called bench trial or a court trial. And that's pretty much a trial where the decider, the decision maker is a judge. There's also the jury trial, which I don't want to say it's more common, but in bigger cases, it tends to be more common. Jury trials tend to be longer, more expensive, more complicated because, the judge is very concerned about not letting the jury hear prejudicial information. Whereas, in a judge-driven trial, all the evidence comes in. It's assumed that the judge can be impartial and make a good ruling just based on on what is relevant and important in a case. So that's the complexity with a jury trial. But either way, you get a result at trial. Presentation is the appellate part, which can be a pretty big deal, especially in a case. Any case, I think, where the verdict is 7 figures, it generally goes to appeal, and that's another big, long, drawn out process. And sometimes appealing a case is, maybe you're appealing it not even because you have necessarily strong merits, but it's just to drag the case out. And maybe if there's a 7 million judgment against you and you put up a good appeal and it keeps dragging out, maybe the other side will settle the case with you for 3.5 million. So appeals can be a very big deal, and if you win the appeal and you get your judgment reversed, then your money and time is well spent. And in the least, you drag things out.
We wanted to give you a little bit of a basic overview of how litigation proceeds and the big important parts, and then I'm going to talk a bit more about how class actions are different. So one of the main difference really is that in a regular lawsuit, you usually have 1 or 2 parties who are bringing an action against one defendant or 1 or 2 parties, a small number of parties. I think of a class action as where you get a group of people, kind of the plaintiff goes and grabs everybody who might be in a similar situation to create a huge class, to make their lawsuit go from 1 person to hundreds of people. And the point of this is that this is really helpful in cases where there are small individual damages. So it might not be worth it to pursue litigation and all of that expense for an action where you might, be entitled to $1,000. But once you get 500 people involved, well, now definitely the defendant's going to deal with you, and you have a much bigger process and you split those costs among everyone. So it's a way to exponentially expand your small damages and create one class action, one action to resolve the matter or try it in court. And so I'll give you some examples of this. I have a pretty big employment law background, so I'm going to use some employment law examples. So one example that we see a lot is a plaintiff who says they worked off the clock. They had to work before they clocked in, and then they had to clock out, and then they were required to do some other things. So then you have all these additional minutes that they have worked, which can actually lead to a lot of different violations of California Labor Code as well. So that's one. Someone might be working 2-3 minutes extra in the morning, 2-3 minutes extra in the evening, and doesn't seem like a big deal, but once you start adding every employee in the whole company, it becomes a big deal. Another issue that is sometimes resolved in class actions is things like medical device and products liability, environmental issues, clip, advertising fraud, kind of these small things that can apply to a lot of people. So there are several requirements that the person who the plaintiff who is requesting that the case proceed on a class basis must meet. The first is numerosity. So they have to be able to show that the class members who they're trying to include as a plaintiff in the class will be so many people or so many entities that it would be impractical to join all the members together. It would be impractical to everybody to join into the action or to do this in some other fashion. Then the plaintiff needs to be able to show that it is an ascertainable class, and this is very important. They need to be able to define the class with enough specificity that we know who is in and who is out. This is fairly easy in my example of the off the clock work, because someone can say, okay, every non-exempt employee in this state, California, who worked between this period to this period would be a member of the class. And that is something that is easily ascertainable from the employer's files And so that's the type of class that you would be able to ascertain, but you need to be able to see the boundaries of who's in and who's out. And this is particularly important because you're going to have to be able to identify those individuals if the class moves forward and there's a resolution that applies to those class members. They need to be notified and provided with whatever compensation or benefit they may get. Next is that you have to have common questions of fact and law. So this again is kind of saying that everybody in the class has to have the same issue. They have to have common questions of fact and common questions of law. You can't combine people where liability would be determined individually for each person. That wouldn't be a beneficial use of a class action or a litigation. Everybody should proceed individually then. And it can be, sometimes it can be, let me give you an example, I guess. So an employee might bring a class action against its employer because its employer allowed its employees to combine its 2 rest breaks. 10 minutes, in an 8-hour shift, you get 10 minutes in the first 4 hours, 10 minutes in the second 4 hours. And this employer allowed the employees to combine their rest breaks into one 20-minute rest break period whenever they wanted to take it. So here you could sue on a class action basis and say, we have a common question of law. Is it legal under California law for the employer to allow that? So that's going to encompass the whole company. We have a common question of law, and we also have a common question of fact. There were employees who took that break, took the 20-minute break instead of their 2 10-minute breaks. And then we have to have these common questions be the predominant factor in the case. It has to outweigh any individual issues that may arise between class members. And these all kind of start to go together. You see the basic idea of what needs to happen. And so similarly, the claims need to be typical. The people in the class have to have similar claims, kind of like the similar questions of fact and law, kind of have to have a similar factual background. That's the basis for the alleged violation or damage. It can't really be based on conduct that's unique to the plaintiff, to the named plaintiff. Because then that would become a major focus of the action and would be against getting into a territory where it's not very beneficial to proceed on a class basis. We should be looking at plaintiff's claims individually or the other class members individually. Okay, adequacy of representation and typicality also similarly go together, and a good representative for the class members. So for example, maybe the employee is alleging that the employer did not give them the required meal breaks, that they had to work on-duty meal periods. And in fact, in actuality, everybody else in the company did have those meal periods, or the plaintiff had a meal period waiver, but no one else did. And this is a situation that they're going to want to litigate, whether that was a valid meal period waiver, whether what they did with that employee was okay, but it doesn't apply to the rest of the employees because they did not have a meal period waiver. So that's a situation in which the named class plaintiff would not be typical or an adequate representative for the proposed class. Superiority, similarly, it's that the class action is the best method to proceed. So we're going to look at some of the major ways to attack those elements and say that the plaintiff cannot proceed on a class basis. The first and best probably is that individuality prevails. So we're attacking that there are common questions of fact and law, that there are predominant common questions here. We're saying, no, you can't lump everybody together. You have to look at everybody individually. There's so many differences. And here's an example. So on the off-the-clock work for the employer. Say the employee filed a lawsuit for off-the-clock work, and they worked in a store in Cerritos down the street, and they're including all the employees all over California. They're going to say, hey, we all had to work off the clock. This is the policy of the employer. And then on the defense side, it's really helpful to go talk to the employer, see what differences exist. It might be that happened in the Cerritos store down the street, but it didn't happen in the Anaheim store, okay? Or the supervisors are different, and a lot of times supervisors are given the capability to manage things on their own. They kind of have different policies and procedures, and that can result in a very different practice between one store and the next. And so that's a really good way, is to identify those differences. Say this manager had a written policy that you had to clock in first thing you did and clock out last thing you did, and the system to clock in and out was at the door. So there could be no work before you went in or out, and then you go, up the state, and that manager has no policy, and the time clock system is, in the back of the building. Maybe some employees go grab their uniform or something before they even get to the time clock. So that's a totally different situation. And we want to draw out as many of those distinctions as we can to say that this is not a beneficial way to proceed with this litigation. It's really helpful for the defense if you can do that, because obviously, class certification is really a make or break component of a class action. If the class is certified, that's a huge pressure on the defendant. If the class is not certified, that's a huge pressure on the plaintiff. Their expected claims where they have, 500 people with small damages becomes a couple people with the same small damages. Obviously not as lucrative or interesting for them to pursue. The other way is to say that that representative is inadequate. And this is what I touched on earlier. There might be a unique defense that the employer has against this plaintiff, that the defendant has against this plaintiff. That would become a big part of the litigation, and it's really not representative of the other class members. And again, my example with the meal period waiver. So the representative has a meal period waiver, but they're trying to assert meal period damages on behalf of all these people who did not have a meal period waiver. Those end up being completely different questions. And so we want to say this person is not an appropriate person to represent this class. Another way to do that is sometimes they're alleging damages that we can show they didn't even experience. So saying, oh, none of us were paid for overtime. And then we go back and look at the representative's time records, and it turns out they don't earn overtime. They only worked 4 hours every day. There's no possible way they could have gotten overtime, something like that. Then they are not an adequate representative. One way that plaintiff can fight back on this too is to name a new representative, but it's still a useful tactic to eliminate some claims or slow down the class action. And then we need to attack that the class action is the superior method by which to litigate these claims. So a great way to do this is to make the plaintiff propose a trial plan. They have to tell the court what they're going to do and how they propose proceeding with this case in an organized fashion that would be easy to litigate this case on behalf of all the class members. So they're going to put in things about discovery and maybe splitting up the trial into separate parts, things like that. And so we have this plan that they provided as defense counsel. And of course, we're going to go through it very carefully and see what we can oppose. You can say, actually, that's not a very good idea. This is going to be so burdensome. This is going to be so hard. This is not the way to do it. And you know what, Judge? There's actually a different way we think you could do it that would be much better, such as sending all of these individual plaintiffs to a small claims court. Or let's do it in one big, let's do it in labor commissioner hearings. Or it might be that, a lot of the class members have already filed lawsuits against the defendant. And so we have so many lawsuits out there in the system that it's just not a good idea to try to pull them into a class action. And the number of individual actions is just gonna block this class action. It's gonna block this effort to put everybody together. Okay. Couple other differences in class actions, some major differences, is that you need to be able to give notice to potential class members. So I touched on this with the ascertainability of a class. You may have received these notices in the past. I think I've gotten one for, a car defect or something. It's just it's like, hey, you're a member of this class. This is what's going on. You can, to kind of notify you that you are a member of this class. And this usually doesn't happen until after class certification or when you're settling the matter, when the parties are settling the matter. Then the class action plaintiffs are allowed to either opt in or opt out, and this can be done either way. The court can require the plaintiffs to opt in. More often, they are given the option to opt out. So with the notice regarding, car defect that I would get is say, oh, you're a member of the class. We might be resolving this issue. Please return this if you want to opt out of the class. And so I'd have to take that affirmative step to opt out, to say, I don't want to be a part of this class. And why I might do that is if, yes, I have this same claim, but my damages are much worse than everybody else. So great. Okay. So that's mostly it for us.
Thank you, everyone. Enjoy your Friday and take care. Be safe.